In addition to demonstrating that they are a victim of a severe form of trafficking and meeting the other eligibility requirements listed at 8 CFR Section 214.11 b, T visa applicants also need to demonstrate that they are admissible to the U.S. or obtain a waiver of inadmissibility. In this video, we'll discuss how to assess a trafficking survivor's admissibility and seek a waiver if needed. When a trafficking survivor applies for teen non-immigrant status, they are seeking admission, even though they are already physically present in the U.S. To be granted admission, the applicant must be admissible or be granted a waiver of inadmissibility of any applicable grounds found in INA Section 212a. T visa applicants, both principals and derivatives, and T adjustment applicants must demonstrate admissibility or be granted a waiver of any applicable grounds of inadmissibility. Grounds of inadmissibility that commonly apply to T visa applicants are health-related grounds under INA Section 212a1, criminal-related grounds including prostitution under 212a2, and immigration-related grounds under 212a6, a7, and a9, including entry without inspection and no passport. To seek a waiver of inadmissibility, a T visa applicant must file Form I-192. To waive any new grounds of inadmissibility at the time of applying for permanent residence, a teen non-immigrant must file Form I-601 along with Form I-485. It's important to identify all the applicable grounds of inadmissibility prior to filing the T visa, as the waivers available at the teen non-immigrant stage are much broader than the waiver available at the T adjustment stage. At the teen non-immigrant stage, two waivers are available: the INA Section 212d13 waiver for inadmissibility caused by or incident to the trafficking, and the 212d3 waiver, which is the general non-immigrant waiver that involves a balancing of favorable and unfavorable factors. These two waivers are available to waive most grounds of inadmissibility if USCIS determines the applicant merits a favorable exercise of discretion. At T adjustment, the only grounds that may be waived are those that were caused by or incident to the trafficking, except for health-related grounds under INA Section 212a1. We recommend the following strategies to best assess and address a trafficking survivor's inadmissibility. First, legal representatives should conduct a thorough screening to review the client's immigration and criminal history. FOIA requests and background checks should be obtained whenever the client has had interaction with immigration authorities, applied for a visa or other immigration relief, been in immigration court, or been criminally charged or arrested. Legal representatives should thoroughly review the I-914, 914A, or 485 with the client, with particular attention to the questions dealing with inadmissibility and criminal history. Legal representatives should check relevant case law and policy guidance to help determine which grounds apply to the client's facts. When determining which waivers may be available, remember to check for a connection between the trafficking victimization and the survivor's inadmissibility. And finally, when a waiver is approved, make sure to check that the approval notice lists all the applicable grounds. For more tips and strategies on how to assess your T visa client's inadmissibility and seek waivers if needed, please see CAS's Inadmissibility Advisory available via the link in the description below. If you have a specific question after reviewing our free materials and trainings, please feel free to submit a request for individual technical assistance by visiting the website on your screen, and we will respond by email. Thanks for joining us today.